Perfect. And I am letting IT know we can begin to broadcast. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3073. United States of America versus Juan Jose Martinez Vega, also known as Chiguero, also known as Gentiel Alvis Patino, appellant. Mr. Gilbert for the appellant, Mr. Richman for the appellate.
Good morning, counsel. Mr. Gilbert, please proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Richard Gilbert, and I have represented Mr. Martinez Vega since his initial appearance in Washington, D.C. in 2006. That means I represented him at the trial, during the first appeal before this court, and on the resentencing. I know from experience that the direction this argument will take will depend primarily on what the court is interested in discussing. But let me just say at the outset that I believe that there are two important legal issues that are distinct, but they depend on which category of putative participant you think is qualifies for the aggravating role. I do think that that's not been particularly set forth with clarity by either the district court or, frankly, by the prosecution in its brief. But one category, of course, would be people whom I have described as employees of Mr. Martinez Vega. Patently, if he's moving literally tons and tons of material, he's going to need people to help him with that, whether it's other vehicles, whether it's other boats, whether it's loading, unloading, and so forth. But as set forth in our brief, I believe that the issue is what is the appropriate mens rea? And I've argued that the only mens rea that would be a violation of a statutory offense, meaning a crime against the United States, is if the participants knew or intended that the drugs would be transported or imported into the United States. I'm aware that in the original appeal at footnote number 9, the court specifically sort of rejected my argument that the mens rea had to be the same as the defendants, but it did not in that footnote suggest what other mens rea might be applicable. The district court has never articulated a different mens rea, despite a specific request on my part at the end of the evidentiary hearing that if the court disagreed with what we asserted was the mens rea, that the court at least make clear what that was. And of course, the court never did express a different mens rea. So I think if you, I think you have to decide that if you're going to consider the employees as being participants in the conspiracy. The second issue has to do with what we've been calling the reinsertado witnesses, the cooperating witnesses by the government from Colombia. And I think the issue there is whether this court is going to adopt the definition of control from United States versus Salinas, which is a case we cited at page 8 of our reply brief. And essentially that says that you control someone when you tell them what to do, when to do it, and where to do it. With respect to the question of mens rea, I do want to caution the court. I know that in finding that Mr. Martinez Vega had the requisite knowledge, the court at one point talked about common knowledge that FARC drugs were going to the United States. But I think that the court was drawing that basically on what it perceived the status of Mr. Martinez Vega within the FARC to be. And I think if you extend that idea, common knowledge extends all the way down to uneducated young men from the village who might be assisting Mr. Martinez Vega on a particular trip. I think what the court is essentially doing is creating a presumption that if you're transporting drugs or trafficking in drugs in Colombia, that you know they're going to the United States. And I think that would be impermissible of the court to do that.
Yes, Mr. Gilbert, in your view, did the district court need to identify a specific participant in order for the supervisor enhancement to be valid?
Well, with respect to the category I've been discussing, I think the answer to that is no, because we don't know who those people were. And there's no way the judge could have said, well, you know, it was Guillermo Lopez. Now, it might be different if Mr. Martinez Vega had some trusted lieutenant that was with him on all his trips and so forth. And you do see that sort of thing happen in some drug cases. But I think it would have been sufficient for the judge, if the mens rea had existed, for the judge to say, oh, those people that helped him move all those uniforms and weapons in the boats were participants, because the drugs were coming back and somehow they knew there were drugs inside the bags, and that
how do you demonstrate mens rea with respect to a group of people or to a group of individuals that are not specifically identified?
Well, I think you'd have to have at least some evidence. After all, it is the government's burden. You'd have to have some evidence that these people, had the requisite mens rea. I know the government has argued that there's an issue of willful blindness, but I think, as we talked about in our reply brief, I think the government had to show something more than just a substantial likelihood of the risk that the drugs would be going to the United States. I do think it's the court has cited to an earlier Martinez case, not my defendant, but from 2007. And I think the court has previously ignored significant differences. Most importantly, that the drugs in that case were seized after crossing the land border between Honduras and Guatemala. So they were in Central America. And I think that the expert testimony, both in that case and this case, is clear that if the drugs are going through Central America, they are in fact going to the United States. But that was not the fact here. And, if an exhibit or a chart has been introduced in evidence, I don't think it's necessary that its evidentiary value be limited to that which was expressly talked about at the trial. And in this particular case, I'm referring to Government Exhibit 320C, which is a map showing the flows of cocaine around the world back during the time of this conspiracy. It doesn't appear in our documents in this appeal, but it does appear in the original appendix at page 1802. You can see that map. And at no point does anybody, the district court, the government, talk about all of those flows of cocaine coming out of the northeastern part of South America and going to Africa or Europe. And so that's where these drugs would have been end up going, to Venezuela, as I tried to describe the geography of Bichada and that part of Colombia. If there are no other questions, I'd like to reserve the remaining 2 minutes.
I just have one quick question for you. So would it not be enough if there's testimony to the effect that everybody in the area knew that the destination of the drugs was the United States, and that testimony was not refuted? Can't that kind of evidence be enough to show that the mens rea that you identify as the mens rea that you think is the requisite one would have been met?
Well, it depends on the nature of the testimony that everybody in the area knew. Mm-hmm. If there's any sort of direct evidence of that, then I would agree. One sort of evidence might be if the village was awash in dollars, for example. Perhaps that would be an argument that, look, you must have known that the United States was involved here. But there isn't any of that evidence. And I don't think that you can just sort of sit there and assume that every little villager or young man growing up in a village on the river would have known something that was known by the higher ups in the FARC. Because remember, going back to Colonel Alvarez Ochoa's testimony, the FARC made it a point not to advertise its drug trafficking.
Okay. Make sure my colleagues don't have additional questions for you, Mr. Gilbert. We'll give you some time for rebuttal.
Thank you.
Thank you, Mr. Gilbert. Mr. Richman?
Good morning. May it please the court. My name is Jason Richman. I'm an assistant United States attorney in the Southern District of New York. I'm a special assistant United States attorney for purposes of this case in the District of Columbia. I did not represent the government at the trial, the original sentencing, or the original appeal below, but I did represent the government at the resentencing in this matter and on appeal. When this court first remanded this case back to Judge Hogan, it remanded it with an instruction that Judge Hogan had not made the requisite findings as to the second and third elements of the aggravating role enhancement under guideline 3B 1.1. On remand, Judge Hogan did exactly that. First, the appellant abandoned his challenge to the third element, that the criminal enterprise was otherwise extensive, and Judge Hogan noted that in ruling on remand. And as to the second prong, that there was a participant supervised by the appellant with the requisite mens rea, Judge Hogan repeatedly, over the course of at least two proceedings, referenced that standard. He reviewed the evidence from a trial that he presided over, a multi-week trial he presided over, that established just that fact. And then he came to a conclusion that was supported by those facts and by the law in determining that at least one such participant existed. That evidence came from, among others, the 4 cooperating witnesses who testified specifically about their interactions with Mr. Martinez Vega. 3 of those witnesses, Mr. Restrepo, Mr. Parra-Diaz, and Ms. Ortiz, all testified specifically both about their own knowledge that cocaine was destined for the United States and about specific acts that the appellant had told them to do. The 4th cooperating witness, Mr. Bolas, testified more broadly, I would say, about his history with the defendant, with the appellant, and about his own knowledge, again, that cocaine distributed by the FARC was destined for the United States. Judge Hogan also reviewed expert testimony concerning the fact that most of the cocaine consumed came from Colombia, which, again, could lead to a reasonable inference that most of the individuals involved.
What is the evidence the district court, you think the district court was relying on to show that the defendant supervised the cooperating witnesses? I'm missing it.
Of course, Your Honor. So I could cite to a few different places, Judge. So first, Your Honor, I think sort of maybe the neatest place to refer would be to this court's first opinion in this matter. And in that opinion, Your Honor, there was reference to testimony of Mr. Parra-Diaz, who had suggested that the defendant may have had a troop, that the defendant had guards, and that there were many people supervised. Ms. Ortiz testified that the defendant was the leader or in charge of the group. Mr. Restrepo testified explicitly that the defendant was, quote, like our commander, our immediate commander.
And what about with respect to drugs going to the United States?
Yeah, absolutely, Your Honor. So I could go one by one for each of those witnesses. For Mr. Parra-Diaz, Your Honor, this is at the supplemental appendix, page 169. He testified that he was told that cocaine, quote, was sent over to the Americans. Mr. Restrepo, Your Honor, testified, this is at appendix pages 256 and 257, that more than one leader of the FARC had told him that cocaine was bound for the United States, and that happened repeatedly in conversations he had. Ms. Ortiz, Your Honor, at appendix pages 196 and 197, testified about seeing US dollars when she was with the FARC. In addition, Your Honor, we cite at our brief at page 18, footnote 4, other testimony, and it was not as focused on this appellant at trial, but other cooperating witnesses who testified. One was Alexis Perez, who testified that it was, quote, normal to hear the comments that the cocaine was coming to the United States because it said that that is the country that most consumes it. Specifically, Perez said that she heard a former FARC leader say that the cocaine was, quote, all coming to the United States. Mr. Bolas, Your Honor, who was another cooperating witness who testified that he discussed US currency with the appellant specifically, that he paid him in US dollars. So, and that's at, sorry, Judge, that's at supplemental appendix pages 266 to 292. So the record is replete with references to the destination of the cocaine being the United States, both from these witnesses, and I think importantly, sort of inferentially, Your Honor, to other people involved. Getting at Judge Rao's question, I think the idea that all of these people were around, all of these people were supervised, and I think the appellant now admits that he did supervise people, but there's a fair inference. It certainly was not clear error for Judge Hogan to rely on the circumstantial evidence of knowledge of some of those other folks.
Did the government and the defense agree in the district court that the mens rea, the requisite mens rea element concerned knowledge of the drug's destination being the United States?
Thank you, Your Honor. We do agree for purposes of this proceeding that we have met that burden. I will say the appellant said—
Do you agree that that is the burden?
I do agree that that is the burden, Your Honor. Yes, that is, there is a world in which, Your Honor, we could have proven that the participants had participated in material support of the FARC or a firearms offense, perhaps, that was related to this conduct. That is not the case in this case. We haven't made that argument. I'm not making that argument today. As Mr. Gilbert referenced at one of the proceedings, and I believe it was the August 2020 hearing and not the actual resentencing, he did make explicit to Judge Hogan that if Judge Hogan disagreed with his read of the mens rea, that he asked Judge Hogan to issue a written order to that effect. That obviously did not happen, and the government has not argued anything to the contrary, and we don't today. And Judge Hogan repeatedly, Your Honor, at both proceedings referenced that he needed to find someone had the necessary mens rea. He references crimes that affected the United States. He referenced what he needed to find to define participant.
So the question I have is on the last point you made, which is where the district court joined issue with where it sounds like the parties were, to the effect that the relevant mens rea question is whether there was knowledge among the participants that the destination of the drugs was the United States. It seems like everybody sort of had that in mind, and there were references to that effect, but where's the best place to look to note that the district court had that understanding as well?
Sure. I think one place to look would be at Appendix at page 338, Judge. And Judge Hogan, at that reference, he said, without going through the rest of the individuals, there are many others, just asking about one other as to the issue of whether you can import their knowledge of whatever offense they were committing would affect the United States. And again, Your Honor, Mr. Gilbert below, and I don't have that site in front of me, but did say, outlined what he argued was the requisite mens rea, and did say to the district court, if you disagree, we do request that you put that explicitly. And during the course, in context of Judge Hogan's evaluation of what a participant was, what the necessary mens rea was, he does reference implicitly and otherwise sort of the need to find the facts we're talking about. Mm-hmm. And yeah, and I think absent other questions from the court, the government would rest on its submission.
Make sure my colleagues don't have additional questions for you, Mr. Richman.
Tell me again where you think the reference you just gave wasn't ringing true to me. Where do you think the best evidence is that connects the district court's understanding of the mens rea test and the district court saying, pursuant to that understanding, I am finding that this or these participants or these cooperating witnesses were supervised by the defendant, and they all understood where the drugs were going with respect to that supervision? Where is that? I mean, your answer was a little bit elusive, and I'm not really understanding. Where did the district, see, if a district court has a very clear understanding that there's a fight over mens rea, and I got to have a finding to protect the record, district court judges normally know how to do that quite well. Where is that pithy finding that says, oh, here's the finding you want? I can't find it.
Sure. Thank you, Judge. So I think it's in a couple places, sort of pieced together from the record. One is that—
No, wait, is there a place where you don't have to piece things together, where there's just this pithy finding and the district court says, you don't want to protect my record, here's the finding?
Your Honor, at Appendix 352, Judge, the district court says, finding that the government has met its burden.
No, that's a conclusion. If there is something, just so you know, when I like to see, if there is such a thing, where the district court is not stating a conclusion that they met their burden. The district court is saying, I know what the burden is. Here's how they met it. Here is the evidence I'm relying on to make the finding I'm making.
Okay, Your Honor, where the district court says this is what I have to find, I think one example would be at Appendix 349, where Judge Hogan said, I have to find a participant, a person who is criminally responsible for the commission of the offense, but need not have been convicted. That means the person must have committed all the elements of the statutory crime with the requisite mens rea. Then the district court.
But you got to connect that to supervision.
Correct, Your Honor. And I think
it's not just, yeah, there definitely were participants.
Right.
You've got to connect all of them. You keep jumping around. I'm not being accusatory. I'm just trying to understand what your answer is.
Sure.
You've got to connect all these pieces, at least to help me understand where is it. I mean, I'm thinking of myself being a district court judge. I know what I've got to find here, and I'm going to say, no, here are the participants I have in mind, whether it's a general group or whether it's individuals. Those people clearly were supervised by this guy. Here's what I'm relying on. And they clearly had reason to know these were drugs going to the USA. Where is that finding?
Sure, Judge. So, and apologies if I misunderstood your question. I'm hearing maybe two parts of the question, Your Honor. So the first one, in terms of when he more explicitly outlined what he had to find, I think part of it's what I just quoted. Right before that, at page 348 of the appendix, he says what the circuit held I had to find was that Mr. Vega, under the guidelines, managed or supervised at least one participant who was criminally responsible for the offense in a criminal activity involving 5 or more participants. In terms of him connecting that question, which I think is the second part or the subsidiary part of your question, in the appendix at 352, 353, 354, Judge Hogan goes through testimony from the cooperating witnesses themselves about some of the important things in terms of their supervision. I don't think, Your Honor, I can't point to a line where Judge Hogan says, these are the individuals who were supervised, but it is clear in context he's referring both to some of the cooperating witnesses and also to some of the other individuals who he did supervise who inferentially had this knowledge.
So the knowledge question, it seems like everybody's joined issue on this. The knowledge question is whether there was the requisite knowledge among the participants that the drugs were headed to the United States.
Among a supervised participant, yes, sir.
Among a participant, yeah. And I'm assuming a participant is a supervised participant. So that's the necessary question. Now, a court can't predict every question that could potentially come up. So you're not always going to itemize everything exactly right because you don't know what the inquiry is going to be later on. But ideally, what you see in the record is something that says I need to find the requisite mens rea for the participants. The mens rea standard, the mens rea question in this case is whether there was knowledge that the drugs were headed to the United States. Here's the evidence that leads me to conclude that the requisite knowledge was there. And then there'd be, 1, 2, 3 pieces of evidence that support the knowledge on the part of the supervised participants that the drugs were headed to the United States. I don't think that's in here. That's not necessarily to say that the government can't win, but I don't think that kind of itemized, pointed analysis and determination is in here. All right. I mean, that seems to be the nature of the inquiry, and you're piecing. It's not to say that you can't piece it together. It's just to say that it's not as easy to find how it was met. Now, the one question I have is how it was articulated and then met. On 352, on 351, to 352 to 353, starting at line 15 of 352, the district court says, and this is where you started with what I think my colleague rightly said as a conclusion, that all the evidence of trial and finding, and considering all the evidence of trial and finding the government has met its burden, and it's more likely than not that one of the individuals managed and supervised was a participant as required under the guidelines. And I'll summarize the evidence briefly that leads me to that conclusion. And so that's a correct statement of the conclusion. And then the district court summarizes the evidence. And the first piece of evidence is that the expert testified that 90% of the cocaine consumed in the United States came from Colombia. Is that a place where you draw the tie that says that here's the standard, I've got to find a participant which requires mens rea, and the first piece of evidence is that 90% of the drugs consumed in the United States come from Colombia?
Exactly, Your Honor. And those were the pages 352, 353, 354. That more specifically is what I was referencing.
But then the rest of the items on 352 to 354 don't necessarily pertain to whether the drugs were headed to the United States. They do pertain to whether Mr. Martinez Vega supervised individuals, and there were individuals in his domain who appeared to be individuals who he was working with and who he was overseeing. But I didn't see anywhere else that talks about the drugs being headed to the United States.
Agreed, Your Honor, and that point well taken. I think Judge Hogan did a good job of repeatedly referencing the totality of the evidence and that he wasn't reviewing everything that was before him, and the government in its submissions did emphasize some of that evidence.
Some of the evidence that the drugs were of knowledge that the drugs were headed to the United States.
Exactly, Judge. Yes.
Okay. Okay, make sure my colleagues don't have additional questions for you.
Oh.
Thank you, Mr. Richman. Mr. Gilbert, we'll give you 2 minutes for your rebuttal.
Thank you, Your Honor. I do think, following up with Judge Edwards' question, I do think it's important to recognize the distinction between the categories of people we're talking about. Many of or several of the reinsertado witnesses who were themselves involved in drug trafficking stated that they knew that the drugs were going to the United States. But the issue with respect to those individuals is, can Mr. Martinez Vega be fairly said to be supervising them? And that's why the second issue that I pointed out to you, whether you are going to adopt essentially the definition of control in the Salinas case, is important, because that actually requires the supervisor to tell the participant what to do, when to do it, and where to do it. One brief example, if I may, there is a place where Parra-Diaz talks about having received a written order from Negro Ocasio, the head of the 16th Front, to go and meet Martinez Vega and obtain this war material from him. Well, that's a perfect example of Negro Ocasio telling Parra-Diaz what to do, when to do, and where to do it. Presumably, there were some complementary orders to Martinez Vega to get him to that same spot at the same time. But that doesn't mean that Martinez Vega was therefore supervising Parra-Diaz.
Well, the one place you do seem to have a problem in terms of the side of the case you're arguing is with respect. How do you pronounce his name?
Restrepo, Your Honor?
Yeah, absolutely. Lookout and his connections with the defendant, and it seemed fairly clear to me he was being supervised by the defendant, and the evidence suggested that he had reason to know the cocaine was going to the United States.
I don't know what evidence that would be during the time that he was allegedly supervised by Mr. Martinez Vega. He was a 14-year-old out working on farms to keep an eye out on anything in Bichada that would harm the FARC's interest. But I don't think he doesn't get involved in the drug trafficking until much later, after he becomes an armed member of the FARC. So my argument there is that the mens rea has to coincide with the supervision. And with Restrepo, I don't think they can do that. I don't think they can show that Restrepo had any knowledge at the time he was a miliciano about where the drugs were going. That was above his pay grade, frankly. So I don't have any further comments unless the court has any further questions.
Okay.
Thank you, counsel. Thank you to both counsel. Mr. Gilbert, you were appointed by the court to represent appellant in this matter, and the court thanks you for your assistance.
You're welcome, Your Honor. It's been a privilege.
We'll take this case under submission.
Number 21-7027, Zurich American Insurance Company versus UIP Companies LLC et al. Appellants. Mr. Klein for the appellant, Mr. Margulies for the appellate.
Morning, counsel. Mr. Klein, please proceed when you're ready.
Thank you, Your Honor. Good morning, and may it please the court. I'm David Klein for the UIP parties. This is a case about D&O insurance, and on summary judgment, the district court accepted two of Zurich's defenses to coverage, we think incorrectly. First, it held that UIP should have been given notice under an earlier 2017 policy because it received an email that it should have recognized as a claim within the meaning of the policy. And I'll explain in a minute why this judgment was incorrect as a matter of law. Alternatively, the district court held that if the claim was made during the period of the later 2018 policy under which UIP is seeking coverage, then the UIP's notice failed the notice condition because it wasn't given as soon as practicable. And this requires application of a reasonableness standard that, in our view, was inappropriate for summary judgment. So let me begin, if I may, by first addressing what happened before the inception of the later policy. In February 2018, Mrs. Koster, who later became a plaintiff against UIP, was seeking to negotiate a buyout of her stake in the company. And her personal counsel sent an email to UIP's outside counsel proposing alternative terms for the transaction. Now, the district court's core error was in concluding that this email was a claim within the meaning of the policy. And the policy defines a claim as a demand for monetary or non-monetary relief. Now, in its briefing on summary judgment, UIP explained that one of the alternatives that Mrs. Koster's counsel had proposed included payments of amounts that she claimed to be due and owing to her. And the district court cited UIP's lawyer's characterization as describing, and I quote, on its face, a demand for monetary damages. And that would have been a claim within the policy. But it wasn't a demand for damages at all. It was a proposal to value sums that Mrs. Koster claimed UIP owed her. And an insurance doesn't cover as a loss an asset that you're not entitled to retain in the first place. I can't, for example, take my neighbor's car and then claim insurance for a loss when she takes it back. And I can't withhold money that I owe her and claim insurance when I pay my debt. And because Mrs. Koster's February proposal triggered no insurance coverage, it triggered no obligation to give notice of a claim within the meaning of that earlier 2017 policy. So the very basis that the district court cited for its ruling was the precise reason that the ruling was incorrect. Now, I'd like to turn to Zurich's, what I consider Zurich's fallback.
It doesn't have to be a successful claim in order to suffice to give notice of a claim, right?
No, that's absolutely true, but it does have to constitute a claim. It has to be a request for monetary relief within the coverage of the policy. And a claim for restitution wouldn't be such a claim. This court in Crocker described what restitution is, and what it is a claim for unjust enrichment. I'm holding something that's of value to me that I'm withholding from some plaintiff. That's different from, say, claims for fiduciary relief, for breaches of fiduciary duty, such as later emerged in this case. In February 2018, there wasn't the hint of a request or an assertion that there was a violation of fiduciary duties. That came later when Mrs. Koster filed her underlying lawsuits. So now let me turn to Zurich's fallback argument that notice wasn't given as soon as practicable after the lawsuits were filed under the 2018 policy. And Your Honor's context is important here. When in the winter of 2019, UIP first submitted Mrs. Koster's complaints in the underlying matters to Zurich, Zurich initially undertook to defend UIP. Zurich knew the dates the lawsuits were filed because UIP had provided the complaints to Zurich. But Zurich didn't deny coverage. It didn't assert that notice was late. It didn't argue that notice had not been given as soon as practicable. Instead, it undertook to defend UIP. It was a few months later, in June 2019, that Zurich decided to deny the claim because of the 2018 email, which it had since received from UIP. And it was only then that Zurich added, in our view, as a fallback position, that UIP's claim hadn't been made as soon as practicable under the 2018 policy. Now, I don't question Zurich's good faith in changing its mind about coverage when it learned of the February 2018 email. It's certainly entitled to make that judgment. We disagree with it for the reasons that I've just described. But Zurich's conduct in initially accepting the claim is inconsistent with the belief that UIP's notice was unquestionably late. By March of 2018, March of 2019, it had all the information it needed to make that judgment. And it didn't conclude at that time that UIP's notice was late. So rather, it was a fallback argument that Zurich embraced only when it changed its mind and decided to deny the claim. And if Zurich itself didn't initially conclude that notice was out of time, then UIP as the policyholder certainly shouldn't be held to a less forgiving standard.
Did they ever say initially that they accepted responsibility under the insurance policy, or did they merely receive something and then upon looking at it realize in their view it was not timely?
So they initially affirmatively undertook to defend my client under a reservation of rights. They certainly had the right to deny coverage later. All right.
Right.
But at the time that they received the initial notice and they had the complaints in front of them, what they agreed to do was defend the claim. They also asked for more information, which UIP provided. The information that UIP provided included that February 2000.
They said as a matter of an enforceable statement that they would defend the claim initially, is your argument?
Well, I'm not sure that I would call it enforceable because they had reserved their rights to deny coverage later. But I'm not arguing that there was a waiver of their rights to do that here. Right. I'm arguing that their conduct, based on the information that they already had at their disposal, the complaints and the dates they were filed, is inconsistent with their position now that but like I say, there's another way to look at it. You said context matters. It may be that after you review what you've got, you realize the delay in time puts us in an untenable position, and there were an awful lot of attorney fees being paid during that period, and there were things going on, and they may have said you should have brought this to us when you first got it. That's certainly an argument that was available to them again in March of 2019. They if you look at the record, and I don't have a case site offhand, but in the joint appendix there is a lengthy sort of a record that Zurich seems to have maintained itself about the nature of its communications with UIP. Mm-hmm. And they indicated that they received the notice March of 2019. I think it was March 8th. And although it had actually been emailed in February initially, and they indicate that, there may be an issue of timeliness. Right. And their view was that they weren't going to pay for pre-tender costs, i.e. the defense costs that had already been incurred, if any, they weren't going to pay for. And there were some, for sure. And UIP didn't take issue with that. That was already water under the bridge in March of 2019. Subsequently, they received the February 2018 email, which long predated the lawsuit or the lawsuits in the underlying cases. And they said, oh, this looks like to us like you already have had a claim. Again, we disagree with that. But really, it was only at that point that they decided, in fact, certainly it was only at that point that they decided to deny coverage. And it was only at that point in their denial letter that they added that we think notice was not as soon as practicable. So that was a fallback argument, Your Honor. And
there's nothing wrong with the fallback argument if it's a winning argument, obviously.
I agree with that. But again, I turn to their conduct Their conduct is inconsistent.
I could see how if prejudice were a relevant component of the inquiry, then you could say that the conduct is incommensurate with assumption that they were prejudiced by this because they were acting as if they had notice anyway.
Well,
If we don't think prejudice is a part of the inquiry, then what does it matter? It's either that notice was given as soon as practicable, or it wasn't. And notice for those purposes wasn't given until 7 to 9 months after the climb, after the
right. Right. And frankly, that's not unusual in the context of a policy like this, which is claims made. We cited cases, but even in the occurrence-based cases in DC, for example, Starks, which is cited by both sides extensively, it was a case where there was a 13-month delay in notice, and that was found not unreasonable as a matter of law. So this is really not a question of a math equation. Is it more or less than another case? I'm not saying
what was impracticable about giving notice when the suits were filed.
Frankly, my client was not well informed, and they've testified to that. They did not appreciate the nature of the coverage, and at the moment that they did, practically within a day, they gave notice. So, that we would cite as a mitigating circumstance, but again, as soon as practicable is a very forgiving standard in DC. You're right that there is no prejudice rule under DC law, but this really goes to the question about whether notice was timely under that forgiving as soon as practicable standard. If you look at a case, for example, like Washington Sports, where the policy was structured very similarly to the policy we have here, and it was a Judge Hogan case. That policy said notice had to be given within 60 days, and it must also be immediate. So structurally, it was very similar to this one, but it was a much less forgiving standard. As soon as practicable is one of reasonableness. And he held that notice that was given on the 60th day satisfied the test. He said that he needed to read the word immediate within the context of the deadline that was set by the claims made policy. And that's the same type of analysis that we think would be appropriate here. And we certainly think that our client, I see that I've long since run out of time. May I just finish, Your Honor? Thank you. Thank you very much. We certainly think that our clients can't be charged with having been unreasonable in their compliance with the policy terms when Judge Hogan found under a similar type of provision that notice was reasonable when it was given on the last day of the policy under an immediacy standard.
Suppose the facts in this case were that your client knew of the policy coverage, just didn't give around to giving notice until the same time that was done here.
Well, I think that would be a different case.
Why?
Because it's contrary to what they testified. They knew the policy existed, but
No. Stay with my hypothetical. Don't go.
All right.
My hypothetical is they knew they had a policy, and they don't deny it, and they didn't get around to giving any kind of notice until the same time they gave on the facts of this case. Does that change your analysis?
Well, I want to make sure.
Reasonableness standard.
Judge Edwards, I want to make sure I understand your question.
They knew of the policy.
They knew the policy existed.
They knew there was coverage. They knew. They knew all the things you were arguing, but they knew. They didn't get around to doing it until the same time they did here. Is it a different result?
Well, I think the mitigating factor that I described would be removed, so it might be a different result. But that depends on how much weight the court puts on the mitigating factor.
So you're saying you should be able to plead they didn't really know, and that excuses it. Because otherwise it's unreasonable. That's your argument. They didn't really know here. They didn't understand what they had. And so that could be 2 years later they gave notice.
Well,
They
it
didn't
could,
really, and they honestly didn't know, and they would win on that if it went to a jury and there was a factual issue, they would win on that. So you're saying the critical consideration here is they just didn't know, and so that's why they were delayed.
the critical consideration, that circumstance would not apply, Judge Edwards, because under those circumstances, the notice would have come after the policy had expired.
Okay, well, don't take it beyond the policy. I'm trying to get you.
Absolutely. You can't, under no circumstances can
So
you.
stay within the policy, but they're just the same amount of time. And their answer is, yeah, we knew, we just didn't get around to it.
All right. If you stay within the policy, then again, it may well be that they would be entitled to coverage even then because they were within the policy, and the policy provides a strict deadline. But to the extent that the court,
go ahead, we'll finish, and then I have one follow-up.
okay, but to the extent, thank you, Your Honor, to the extent that the court feels differently, then I would still say you should consider as a mitigating factor their plea of ignorance, which is uncontroverted on the record.
I mean, the first thing you said made it sound like as long as it's within the policy, it's okay.
Right.
But that's just not what the policy says.
That's not
The
what the
policy
policy
says as soon as practicable, but in any event, no later than 90 days. And so there's a different requirement. It has to be as soon as practicable, regardless of the 90 days.
Right, but there's a lot of case law under the bridge on what as soon as practicable means, and it's a very forgiving standard. Again, as soon as practicable commonly means, a longer period than this policy even covered. I read that in the context of a claims made policy with a hard deadline as an exhortation to give it as soon as practicable, as soon as reasonable in all the circumstances. And that's the way Judge Hogan read a similar provision in Washington Sports.
Mr. Klein, can you cite any case in which ignorance about a contract's term affects, the reasonableness of some action within that contract? I mean, that doesn't seem to be consistent with ordinary contract principles in the District of Columbia.
Yeah, I believe in our briefs, we actually cited a case like that. And I'll confess that I have, there was a District of Columbia Court of Appeals case, and it in turn cited a Southern District of New York case. And I just don't have it at my disposal, but I'll try to
Look for it and try to get it on rebuttal if you'd like.
I beg your pardon?
You can look for it and try to give us a citation on rebuttal.
I will, Your Honor. Thank you.
Let me make sure my colleagues don't have additional questions for you
No.
this time. Thank you, Mr. Klein. We'll hear from Mr. Margulis now.
Thank you.
Thank you, Your Honor. May it please the court, Andrew Margulis for Zurich American Insurance Company. And I'd like to start with the last argument. And while Mr. Klein was calling it a fallback argument, we don't view it as a fallback argument. We view it as a secondary argument that shouldn't even be reached, because you only reach the timing of the notice of the lawsuits if we first find that the February 2018 email was not a claim. So if the lawsuits were the first claim,
a fallback argument and a secondary argument that doesn't need to be reached. Isn't that a fallback argument?
Right.
well, it could be, but we do view it as we do view that as two very separate issues. And getting to this issue, as Your Honor pointed out, it is as soon as practicable. That is the standard, and in no event later. So it is not either or. It is not you get to choose what you want to do, either as soon as practicable or later, or 90 days after the policy period. It is still as soon as practicable, and the 90 days only puts an end limit. And the Washington Sports case that Mr. Klein cited was very different. That policy said immediately, but no later than 60 days. That 60 days was measured from when the claim was made, not at the end of the policy period. Here, using Mr. Klein's argument, taking it out to the extreme, if an insured was sued on the first day of the policy period, under Mr. Klein's argument, he could wait 15 months, the 12 months of the policy period plus 90 days before giving notice, and argue, well, we beat the 90 days after the policy period, so we're fine. That still does not meet the as soon as practicable test. And an insured cannot argue that they were ignorant of the terms of their policy and understand that they had coverage as an excuse. That would turn a notice provision on its head in every insurance policy every insured could just come in and say, well, I really didn't understand I had coverage, so therefore I was excused from giving notice timely. These are sophisticated business people who have sophisticated employees and who have insurance brokers, and they should understand the policy. They bought a policy. They were sophisticated enough to buy a policy to cover risks. They are charged with the knowledge of that policy. We do not believe that giving notice 9 months after lawsuits is as soon as practicable. And the other argument Mr. Klein made in terms of Zurich accepting coverage and agreeing to defend, as Judge Edwards pointed out, Zurich did not accept coverage. They reserved their rights. And what happened here is, as your honors I'm sure understand, the one thing that insurance companies hate more than anything else is a surprise. And Zurich was given notice of 3 lawsuits in March of 2019, 3 weeks before trial was scheduled. And Zurich was scrambling, trying to figure out what was going on in the claim, getting additional information. They immediately requested additional information from UIP, got some correspondence that dated back to 2017. And there was a reference in one of the emails that suggested there was a settlement demand. And Zurich then asked for a copy of that settlement demand. And it wasn't until May of 2019 that Zurich was first given a copy of the February 2018 settlement demand. And within several weeks, Zurich came to the conclusion that that was a claim in the prior policy period and should have been reported and was not. So Zurich was being very diligent in, on the one hand, trying to get up to speed on the claim, and there was a trial coming up, and trying to get information about that to see what kind of exposure they may have for the claim, and at the same time evaluating coverage because of everything that happened. So they were acting diligently. They at all time reserved their rights. And as soon as they had the necessary information, they took the coverage position that there was no coverage. And going back to the February 15th email, the 2018 email, the fallacy of UIP's argument is that it was just a communication between parties and a buyout of shares. And that is not what the email says. The email very clearly states, and again, this is going back, this is an email that came after 2 years of disputes between these parties, of letters back and forth, claiming money was owed, claiming improper conduct. And finally, this email came that is labeled inadmissible settlement communication. And the email states at page Joint Appendix 385, Mrs. Koster is willing to enter a global resolution of claims for past conduct and to relinquish her equity interest. This was more than just a purchase of an equity interest. This is to settle claims. And she went on to make demands for money. Those included percentages of past profits she wasn't paid, and a $300,000 payment for loss of the profits and dividends, and for not being permitted to be involved in management of the companies. And those were her damages. And Mr. Klein can argue restitution, but the cases that he cites and all the cases that talk about restitution are very different cases. You have the level 3 case, for example, which was a stock rescission case. And the insureds there obtained money for stock sales based on allegedly fraudulent representations. And when it was found that they had committed fraud, they were ordered to repay the purchase price of the stock. That's restitution. This is not restitution. This is a party claiming they had certain rights, they were entitled to certain payments, certain distributions, they were entitled to be involved in management of the company, and they weren't permitted to do that. And she was damaged. And that was exactly what this email was, a demand for damages. If UIP had been required to pay Mrs. Koster these amounts, they would have been damaged. And these are the amounts that Mrs. Koster ultimately sued for in her lawsuits. These were the damages she was claiming. So clearly, these are the monetary amounts she was seeking from UIP. And this is the very reason why policies like this have a definition of claim that is more than one prong, because it is understood that before a lawsuit is filed, there are often written demands. And sometimes they never go to lawsuits, that these things get resolved based on the written demands. But that's a claim. And Zurich is certainly free to choose how to define a claim, and it did so here. And a claim is a written demand, and this is a written demand, and it is not for restitution. So there is no doubt that this was a claim as defined in the policy, and that they were obligated to give notice within 90 days after the end of the policy period, which would have been May 2018, and it wasn't until March of 2019 they gave notice. Now, again, turning back to the lawsuits, even if this document was not a claim and the lawsuits were the first claim, it is still not practicable to give notice when you get lawsuits in June and August of 2018 to give notice in March. They certainly could have given notice sooner. And the only excuse they have, as Judge Edwards pointed out, is that they just weren't aware of their coverage. That may be true or it may not be true, but the insured's subjective belief cannot override what the contract says. It is an objectively reasonable standard that has to govern these situations. Otherwise, as I said, every insured could come in and say, I didn't understand my coverage. I didn't understand this is something the insurance company would have wanted, so I'm excused from my obligations under the policy. And that would create a situation of uncertainty, and no insurance policy could ever be enforced in those situations. And that's why it has to be an objective standard, so these policies can be enforced as they are written. And if your honors have no further questions, we will rest on our submission.
Thank you, counsel.
Thank you, Your Honor.
Mr. Klein, we'll give you 2 minutes for rebuttal.
Sorry, it took me a moment to unmute there. So first of all, I want to give the court the citations that I referenced. One of them is Starks, which is a case we've cited over and over again, 408 A second at 982 to 83 and note 6. It specifically cites lack of knowledge or lack of appreciation of the coverage as a mitigating standard. This court also, in American Institute of Architects, a case that we cited, said the same thing, 986 F second 1455. So Mr. Margulis is incorrect in arguing that the insured cannot argue ignorance. The insured can't argue ignorance as relieving him of all obligations, but he can certainly argue ignorance as a mitigating consideration, because that's what this court and the DC Court of Appeals have said in interpreting DC law. Mr. Margulis referred to, described what happened between March of 2019 and June of 2019 when Zurich changed its position regarding coverage. I'm not arguing that they had waived their rights or they had failed to reserve their right to deny coverage later. But the fact of the matter is that Zurich understood in March how long it had been since the complaints were filed. And it didn't decide then and there that the complaints were unreasonably late. It may have thought that that was possible, and there's evidence that it did think it was possible. But it was only after it received the information about the February 2018 email, which we believe it misinterpreted, that it decided to deny coverage. And it was only at that time that it changed its position. Ultimately, the test is what the insured could reasonably have believed were its obligations under the policy. And again, under a policy that has these dual tests of time, we would take the position that the insured could reasonably have believed, as Judge Hogan did in Washington Sports, if the court has no further questions.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you, Your Honor.
Case number 20-1411 et al. Everport Terminal Services Inc. Petitioner versus National Labor Relations Board. Mr. Parrish for the petitioner, Everport Terminal Services Inc. Ms. Malio for the petitioner, International Longshore and Warehouse Union. Mr. Sauter for the respondent. Mr. Rosenfeld for the interveners.
Good morning, counsel. Mr. Parrish, please proceed when you're ready.
Good morning. Thank you, Your Honors. May it please the court, Ashley Parrish for Everport. This case involves a dispute over which union Everport should have negotiated with for the maintenance and repair work at the terminal it operates in Oakland, either the longshoreman, the ILW, or the machinist, IAM. Everport's position is straightforward. Because the board has designated the longshoreman as the coast-wide unit, we were required to agree to the longshore contract, which required in turn Everport to use the longshoreman for this work. As Your Honors may have noticed, there's a There's a disconnect in the briefing. The board never meaningfully engages with our basic argument as to why we are obliged to work with a longshoreman. And there's a reason for that. The board is using this enforcement case, it appears, to try to change the rules that it has put in place and that have governed the work on the ports for decades. This morning, I'd like to focus on 3 points. First, I'll explain.
Longshoremen did not historically have representation rights in this group. That came years after it started. So that is kind of a fabricated assertion on your side of the case. I'm not saying you're fabricating, but that is not a correct assertion. That came after a long period of time. The point, I'm most interested in hear what you have to say. What the board is doing is saying that whatever you think your contractual arguments are, they don't trump the successor rule. The board has a legal rule they're relying on. They say the successor rule applies, and that's that. And they do not agree with you to the extent that you're arguing it, that there was any accretion upon which you could rely. Those are legal determinations, and I don't know why we don't defer to them. They said the successor rule applies, and you can't argue that your notion of the contract trumps that.
Okay, so Your Honor, let me take that in terms. First, let me be clear, we're not arguing accretion. What we are arguing, though, is that the board has set up a process where, as the employer, we have only one choice. If we want to operate a terminal, we must have longshoremen. Those are the folks that take the cargo off of the container. So we have to enter into a contract with the longshoremen. The only way to do that under the history, and this is a long history, Judge Edwards.
But it doesn't start from the very beginning.
Your Honor, it may not, but,
but that's in the context of this case, that's not insignificant, because you're suggesting something that is inaccurate. It hasn't always been this way. The machinists have been around, and the machinists were properly around before this change, and they had bargaining rights. So, I mean, you're making an inconsistent argument. You're saying there's no conceivable way the machinists can be here in this area because the longshoremen always, well, that's not true. The machinists were here properly, and there was no claim that the longshoremen could have come out and moved them out when they were there before these changes were made. And what the board said was, under the successor doctrine, the machinist, the employer is required to recognize the machinist, not the longshoreman.
So, Your Honor, with respect, I understand your question and I understand how you framed it, and I agree with how you're framing it, but I disagree with your premise, and I'm not debating with you that the machinists have been here for a long time. What I'm saying is, for the stevedore work, not the repair and maintenance, let's put that aside, for the stevedore work, which any terminal operator needs to use, there is only one bargaining unit that's been deemed appropriate by the board. That is the longshoreman. And that has been true for a long time. Now, Your Honor, I agree with you. There has been a long-running dispute between the two unions as to which union is responsible for the maintenance work. And the longshoremen will tell you that for a long time, this type of maintenance and repair work is something they've been responsible for. But Your Honor, I don't need to win that argument. What I need to tell you is that the board has set up a system that if I want to operate the port, I have to go to the longshore for the stevedore work. And because the board has designated them as the appropriate union, there is now the longshore contract. Now, the board does not dispute that we needed to enter the longshore contract with them, nor does it dispute that the Ninth Circuit decision from just last year says that under that agreement, it's unambiguous that this maintenance and repair work in general must be assigned to the longshoremen. And so the problem, Judge Edwards, is we are in the middle. I'm sorry, Judge Rapp.
Oh, and Mr. Parrish, I mean, my question, I guess, is a factual one. I mean, could Everport have hired longshoremen without joining the PMA? Would it have access to longshoremen without joining the PMA?
Judge Rao, my understanding is no, and and for two reasons. One is that we, as a matter of longstanding principle, it has been a multi-employer bargaining unit, which is the Pacific Maritime Association, the PMA, and that we could not individually bargain with the longshore union. And two, because the longshore union has this collective multi-employer, the only way we could do that is to join the longshore contract. with them.
So you're saying that's true as a matter of law, not just as a practical matter, because that's what I wasn't clear from the briefing. I mean, it sounds like practically speaking, that's true, but I'm wondering if that's also formally true as a matter of contract.
It is both. It is both.
Okay.
Well, I'm sorry. Let me say it's both, with the exception of the last bit that you said, which is that the reason it is legally true is because the board has decided that the longshoremen are the coast-wide bargaining unit, and because of the existence of the PMA. Now, Your Honor.
But that's a different question, though. So they might be the coast-wide bargaining unit, but does that mean that you have to join the PMA in order to bargain with them?
Under the way it's been set up, yes, by the board. And Your Honor, this is not something. What our main point here is that the board is free to change the rules. Now, there's good reasons why the board wouldn't do that, but the board is free to change the rules anytime it wants prospectively. And if you take a look at, say, for example, the 1981 PMA decision, the board has looked at these specific contractual provisions and it says they're fine. It has enforced them. It's even held there's an unfair labor practice against the IAM for not complying with these provisions and trying to get work, maintenance, and service work that was assigned to the ILW. Judge Rao, I think
I guess my question in part arises from the fact that it seems like there's this, I mean, as you mentioned earlier, right, the board and your arguments and the board's arguments are talking past each other to some large degree. And the board is talking about successorship and you are talking about your obligations under the contract. And so I guess my questions are really running to, did you have to enter into this contract? I mean, it seems like some of the board's arguments are you didn't have to join the PMA in order to run your business. But it sounds like what you're saying is you did have to join the PMA.
Your Honor, I am saying that. I am also saying that the board has never questioned the lawfulness of joining the PMA. It doesn't dispute. In fact, it concedes that the longshore contract is controlling. And in the test that they apply under the Burns test, it's a question of what is the appropriate bargaining unit, which unit, and that's answered by the system that the board has put in place.
The PMA doesn't conclusively determine as a matter of law that with respect to disputed work in an appropriate bargaining unit, it goes to the longshoreman, because in this same unit, before this dispute, the machinists represented the employees in the appropriate unit. I mean, that's the piece that makes no sense in your argument. This is the same unit. It was red marked or whatever you call it. It was understood by everyone that the machinists are the representative in this piece. Okay, it's just like a little lump in this whole coast. There is this piece, and this piece is represented by the machinists. No one ever assumed that the PMA said otherwise. No one. So all you had, the facts that now come up is the employer said, okay, we're going to close it down for a minute. Okay, we're opening up for a minute. And now we're going to continue. And the board said, yeah, you're right in the successor area. And the law is the machinists continue to represent, period.
So, Your Honor, you put your finger right on it. And that's a problem, which is that under the longshore contract, there is a red circle requirement, which is why the machinists were at that time appropriate union. Under the interpretation of that contract by both PMA and by the longshoremen, the board does not dispute this and defers to that interpretation. We are no longer red circled because Everport took over the operations and did not have a pre-existing relationship with the machinists.
A successor, but the problem is there is a fiction that we accept there. That when you have a successor, they did previously represent. That's the law. You're running up against, you're trying to say our contract trumps the legal requirement. And you're trying to say your contract is the legal requirement. That's not correct here, because the successor rule is a rule. There is a fiction. It assumes that the employer is still there. That's what the successor rule assumes.
Your Honor, I completely agree with you that that's the successor rule assumes. The successor rule says you must identify the appropriate bargaining unit. The board has set up the system that the appropriate bargaining unit for stevedore, longshoreman work, is the longshoreman. It's a coast-wide unit. The board has allowed them to have a collective bargaining agreement with PMA that governs all the ports up inside the coast. And as the Ninth Circuit decision makes clear, that agreement says that all new maintenance work that's not red circled has to go to them. As the
Are you
employer,
saying that the work that's being done in this area, Evergreen, Seaside, Marine, is different than what was previously being done?
Your Honor, I'm saying that that under the longshore.
No. Answer my question. Is the work different?
Your Honor, most largely no. If you look
No.
at the record,
Okay, that's what I thought. So different employer names, but the work's the same, right?
Correct, Your Honor.
Okay, so forget your contract, because quite frankly, that's your biggest problem. The contract doesn't trump the law. So the work's being done. No one, not the board, not the longshoreman, no one assumed that the unit as constructed before this change was improperly assigned to a union that did not have bargaining rights. They had bargaining rights that were not impermissible under the law. There was a moment when they closed that and then they reopened. And under the established law, the board said they didn't really close. It's a successor. That's your problem. Your view of what the contract, the PMA may or may not say is not correct, because the successor rule trumps you out.
With respect, no, Your Honor. And the reason is because the board gets to choose which is the appropriate union. The board
did. They said in applying the successor rule, they are making a determination as to the appropriate unit. That's exactly what the successor rule is.
But Your Honor, the successor rule says what's the appropriate union. You then have to look at what the appropriate union is. What you're saying is the default in any other situation would be that it would be the existing unit. The problem is that in the coast, on the West Coast, we were in a situation where it was lawful for us to join the PMA, and under the terms of the longshore contract that the board has essentially approved, that work has to be assigned, and the appropriate unit is now the longshoreman.
The is now is your problem, because there's nothing that's changed.
Your Honor, the problem I have is that as the employer, there is nothing I can do. If you were to agree with the other side, then I would have an unfair labor practice against me for not complying with the contract, because the board would say,
oh, you know what? I'd take good odds on your side that you'd win that one hands down if you had an opinion from this court that said the successor rule trumps and that they are bargaining with the appropriate union in an appropriate bargaining. I don't think you may have other problems. I'm no fool. I understand when you got two unions fighting over this kind of work, you might run into other problems, and as the employer, you don't want the aggravation. But that isn't the question.
Your Honor, the problem is that that's all prospective looking. If the board wants to set up that system, it can easily say, look, the coastwide bargaining unit will not be the longshoreman. It can easily say that the longshore provisions in the contract that say that this work must go there.
We're going around in circles because the board has already said
but Your Honor,
that this piece belongs to the machinist. They already said that. And you're saying, but wait, it's not there anymore. And the board said, sure it is, because of the successor rule.
Your Honor, the Ninth Circuit last year in the decision we cite, the Kinder Morgan decision, rejects the board's position and says this piece does not belong to the machinist. It belongs to the longshoreman.
So can I ask the following question, which is, you have one set of arguments that you think you need in order to win at the end of the day. I'm more interested in what we should do with the case that we have right now. And it seems to me that the way Judge Edwards understands the relationship between the successor rule and what you're thinking is your contractual obligations, that may be the state of the law. And if the board announces that that's the state of the law, well, then you've got something that you need to contend with, because it's at least conceivable as a matter of law that the successor rule trumps contract. That could happen. You may think that that doesn't make any sense, and that puts you in a bad position, and that's unworkable. And then that's just something that the board's going to have to contend with. My question is, even if that's where the law ends up, does the decision that we're reviewing do the work? Because one other way to look at it is that maybe the board reaches that conclusion at the end of the day, but we just can't tell from the ALJ opinion that was ratified by the board that it engaged on these issues. And unless and until we see that the board is engaged with it and thinks that even in the contractual scenario that you outline, the board's decision can't be affirmed on that basis. And for example, one question, you need to win on the red circle exception not carrying forward, even under your theory of the case.
Right.
And right now I know that you assume that, and you say that the board doesn't contradict that assumption, and I take your point on that. But at the end of the day, for you to prevail, that would need to be true.
Right.
And one question I have is, an intermediate way to look at the case is, regardless of whether you're right or the competing way of looking at it is right, which is that the successor rule just carries the day over and above the contractual obligations that you say you have, that we just can't discern that conclusion from the board's reasoning at this point. And so it at least needs to go back to the board for the board to wrestle with this.
Your Honor, I completely agree with that. And I think that under the Ports American case, this court decided in 2020, the board's failure to engage is a reason to remand. The challenge we have, Your Honor, is that you will see that if this was a question as to what the right policy should be going forward, we would completely agree with you that there's no more role. The problem that we have is not that we're asking whether the contract trumps the board's rules. What we're asking the court to find is that the board's rules trump the board's new rule. And the problem is that we're put in this position where in an enforcement context, the board has never, and in fact, on its brief on appeal, appears to concede the logical steps in our argument. So the reason why I agree with you, Your Honor, that at a minimum you need to send it back is they haven't engaged. But if you look at the concessions they've made and the decisions they've made in the past as to how they've set up the bargaining unit, this is not an enforcement case. This is a question of the board changing its policy, which it's free to do going forward, but not retroactively.
Well, even as to that, I mean, that might be an argument that you have in your back pocket no matter what. But for us, at least from where I sit, it's a little bit difficult to understand how all these things interrelate until I see an analysis and an explanation that elucidates the board's perspective on how they do.
Your Honor, I mean, it's a fair point. There's no doubt that the board has not engaged. It doesn't even engage in its brief before the court. So I understand why the court feels at sea in terms of addressing the issues.
Mr. Parrish, I guess following up on Judge Srinivasan's point, I mean, do you think that there's an argument that as a matter of law, the contract needs to trump the successorship rule? Or do you agree with Judge Srinivasan that, on remand, the board is free to decide either direction?
So thank you, Your Honor. I don't agree that the board is free to decide either direction on remand. And the reason is because it's not that the contract per se trumps, it's the fact that the board has made the decision that the coast-wide bargaining unit is the longshoreman. And once it did that,
you keep, when do you think they did that? The history doesn't support that. The machinists have been around. We're just going in circles.
No, Your Honor.
Machinists have been around before. They were been around in this particular area, which is coast-wide.
Your Honor, I'm sorry, you think I'm disputing that with you, and I'm not. What I'm disputing with you is that for the stevedore work, itself, that's something the machinists have never done. That's only the longshoremen.
I asked you well into the argument, is the work being done in this area, which is not new, it's just new employers, the same work? And you said yes. It's the same work that was done before. And then I said, and the machinists were the representatives, right? And you said yes. So your argument's not making sense, and my colleague may be right. It may be that we're just going to keep going in circles, and maybe the board has to clarify what they're talking about. But your claim that this is somehow new doesn't make sense on the record of this case. It's not new.
So Your Honor, the problem is that I'm not being clear enough to you because I'm not going in circles. I understand what you're saying, and I'm trying to respond. What I'm saying is that there is first, we know that the stevedore work has always been the longshoreman. We all agree with that. There has been, as the process that the courts have changed, there has been a long-standing dispute as to what to do with the work that can be done by either the machinist or the longshoreman. That is in the record. You can see it in all the board's decisions. These decisions come up all the time. Then what has happened is that since 1978 and through the 1980s, there has been the longshore contract, which the Ninth Circuit last year ruled, contrary to the board, unambiguously assigns repair and machine work to the longshoremen. And so, Judge Edwards, what I'm trying to say, and Judge Rao, what I'm answering into your question, is that because the board has set up a system where they've given for the stevedore, the longshore work, to the longshoremen. And the longshoremen have then negotiated a long-standing collective bargaining agreement that covers more than just that, Judge Edwards, that goes into the work that the machinists also do. But the board has looked at that many times, and it has many times said that those provisions are appropriate. And then last year in the Ninth Circuit, it was clear that the Ninth Circuit said that unambiguously includes this type of work. And so, Judge Rao, the answer is when you put those two things together, there's only one result, which is that the board would have to reach the conclusion on remand that there's a legal requirement that we did what we were supposed to do, and the board would have to change it going forward.
So just so I understand, so your argument is that if they wanted to change it going forward, they would have to engage in rulemaking, that they can't do this through an enforcement action?
I'm sorry, Your Honor. Yes. So there's a couple of provisions. They could do it under Section 9 of the Act and Section 10. One is a complaint against the union. So there could be a complaint relating to the contract itself. And then the board could look at that and say, we don't think those contract provisions. So it could address Judge Edwards' questions and say, look, we think this work really belongs to the machinists, not to the longshoremen. We don't think the Ninth Circuit was correct about this, or in any event, we think that the provisions are improper, and it could change the agreement if it wanted to. And then under 9, it has the ability to certify an appropriate bargaining unit. It could, if it wanted to, open all this up. And I'm not suggesting it would want to, because there's a lot of history here. But the reason why it selected the longshoremen as the coast-wide bargaining unit for the longshore stevedore work a long time ago has some reasons, but it could open that up, could change that if it wanted to.
And so absent those actions, your position is that making that decision in your enforcement action would be impermissibly retroactive.
Right. What we did was the natural consequence of the system that the board has set up. And the problem is that the board's arguments about successorship don't address the threshold question, which is what is the appropriate union? We have this threshold argument that says in figuring out the appropriate unit, you have to look at what the board set up with the system it's done in terms of having this coast-wide unit.
Was the prior unit appropriate?
Yes, Your Honor, because
okay. Well, I mean, that's the problem. I mean, you know what I'm going to now ask. If the prior unit was appropriate, under all of your analysis, contract, legal, and everything else, if the prior unit was appropriate, what you're looking at is a situation where the board is essentially saying the prior unit still exists.
Sorry, Your Honor, the prior unit was appropriate until Everport took over the port.
Well, we're going in circles, because that's how does the successor rule come in?
No, Your Honor, no. So what I'm saying, Your Honor, is that in terms of asking the appropriateness question before you get to the successor rule, what you would say is that we're bound by the collectively bargained agreement. And under that, it has rules for red circling as to when a unit that was previously appropriate remains appropriate. And the distinction there, which the board does not dispute, is whether there was a pre-existing relationship. If Everport had a pre-existing relationship, then under those circumstances, the machinist would have been appropriate and would have remained appropriate, and we would have had to, under the longshore contract, continue working with them. Okay. Which is why they remain there, because under the Seaside and the two organizations that work for Seaside, there were that pre-existing relationship, which is why the machinist continued under the longshore contract.
Typically, if we vacate an agency determination on arbitrary and capricious grounds because it hasn't wrestled with some of the arguments that you're putting forward now, it goes back and the agency can do it again. And the agency is free to reach the same result. It just has to come up with reasoning that's non-arbitrary and capricious in order to sustain the result. And then that's judicially reviewed. And then the court that reviews that determines whether the new determination survives scrutiny.
So Judge Srinivasan, let me see if I can be really clear, because I think I understand you exactly. If we think that if you piece together what the board has said before and what it doesn't dispute here, there is, to answer Judge Rao's question, there's only one legally permissible determination here. But I agree with you that if you don't agree with that, and if you agree with that, it would save everyone a lot of trouble from going back and forth. But if you don't agree with that, in the sense that you can't piece it together, then obviously you can remand, and we can be back before the court on the same issues.
Right. You can make the same argument before the board to tell the board on remand, actually, you don't have any discretion, and this, based on the Ninth Circuit decision and the other understandings, you can only go one way unless you're only going to do it prospectively. And then we'll have to see what the board says about that. And then a court that's reviewing that determination can make an assessment.
You're right, Your Honor. The only thing I'd say is we've said it and the board's conceded all of the central things. And the reason why it isn't engaging is because it has no answer, because there is no answer, because all it says is, Judge Edwards, which is your analysis, which is, successorship. But the problem is that there's a step before that, which says what's the appropriate union. The board has put that in place, and the board doesn't dispute any of the threshold. He agrees with us that it was fine for us to join the PMA. It agrees with us in its brief that the longshore contract is governing. And once it's made those two concessions, and it agrees that the longshoremen are the appropriate unit, once it's made those three concessions, there's nowhere else for the board to go.
Well, unless the board thinks that the way the successor rule operates is that when you have a phenomenon like the red circle exception, that just essentially, the successor rule just essentially makes that permanent.
Right.
Except for, Your Honor, it has not made those.
I understand. I mean, we're just going in circles. Yeah, I hear you.
Okay. Thank you.
Let me make sure my colleagues don't have additional questions for you at this time. You have a little bit of time. We'll give you a little time for rebuttal. But let me make sure we don't have further questions for you at this time. And we'll hear from your colleague on the same side, Ms. Malia.
Good morning, Your Honors. May it please the court, Emily Malio for Petitioner ILWU. I would like to start my argument addressing the questions of successorship that were brought up earlier. And in particular, the board's finding here on successorship depends on its finding that Everport discriminated against machinists in hiring of mechanics, and that but for that discrimination, they would have
Discriminated against who? Said machinists?
Yeah, the machinists.
Right.
And but for that discrimination, a majority of the employees hired would have been machinists. That is a necessary element of successorship under the board's case here. Now, the board, though, found that discrimination because Everport followed the Longshore Agreement. So there really is no way to divorce these two concepts. The successorship depends on a finding that complying with the Longshore Agreement, specifically the requirement to exhaust the hall before you consider any external applicants, was unlawful discrimination. And for that reason, I think it is important that successorship is not just based on the facts that are not contested here, that the work remained similar or that there was these prior historic bargaining units before Everport took over. The question really depends on, was it discrimination, unlawful discrimination for Everport to comply with the contract? And likewise for my client, did my client violate the act by engaging in conduct that I think the act was enacted to protect, ensuring compliance with this collective bargaining agreement and advocating for the workers it represents?
Ms. Malio, could Everport have hired longshoremen without joining the PMA?
No. The only way to access the pool of longshoremen as well as marine clerks is to be bound by the Longshore Agreement. And
it's the only way. So longshoremen who are members of the ILW don't work at any of the non-PMA ports at all?
Or terminals or for non-PMA?
Terminals or no. So they only work at PMA.
That's correct.
At terminals. Yeah. Okay.
Yeah, it's not the sort of contract where an employer can, access the pool of workers and just say, okay, we'll comply with the economic terms. I know there are those types of contracts. This contract does not allow that. You have to be bound by all of the terms of the agreement, be part of the multi-employer bargaining association in order to
access those workers.
Access the workers.
Okay. Thank you.
You raise an interesting point. I mean, which was a little bit perplexing to me. You're essentially saying that, you're saying directly, the discrimination occurred in following the alleged contract rules, which required them to hire the longshoremen. You're giving preference to longshoremen when you shouldn't have, right?
I believe so, but it's a longshoreman and marine clerk. So when Everport joined the Pacific Maritime Association, became bound by the agreement, the ILW demanded and Everport complied with its obligations to hire marine clerks, with its obligations to hire longshoremen. With the exception of longshore mechanics, both of those aspects were not a concern at all.
What the board seems to be, in your analysis, the board seems to be doing or saying or suggesting is that to the extent that that contract gave preference to longshoremen in areas in a unit that was always understood to be manned by or peopled by machinists, that was impermissibly discriminatory, and it's not going to trump the successor rule. That's essentially what the board seems, in your view, seems to be doing, right? In other words, yeah, there's the contract, but the contract's discriminatory. So we're not going to fight you on whether you had to join in that contract. The red circle still should continue, but not in this modified form, which gives preference to the longshoremen. That's what the board seems to be saying, right?
I mean, to the extent I understand the board's theory in this case, I believe it is that Everport discriminated against the machinists by applying the longshore contract. But at the same time,
by applying the modified notion of the red circle. In other words, because previously it was clearly a recognized units with machinists in it.
Well, I mean, I wouldn't say it's a modified contract. Both the parties.
Well, modified application of the red circle.
Yeah, the parties who bargained the contract, PMA and the LWU, both agreed that the red circle expired when MTC, the formal operator, left the Nutter terminal.
Right, that's what I mean. The red circle was no longer there.
Right, and that
was
also
was saying if that results in your now hiring people in a discriminatory way, so that the people who formerly worked in this same successor area are now being denied jobs or limited jobs, that's discriminatory, and it's not going to avoid collision with the successor rule. That's essentially what the board seems to be saying, right?
Yeah, that complying with the contract, that Everport, by complying with the contract, that is the action that leads for the but-for determination, that but for compliance with the contract, more machinists would have been.
Yeah, I mean, and this is where I disagree with your colleague on your side, I'm not saying that the board is right, but our understanding of what's going on seems to differ. The board can say that a contractual provision results in impermissible discrimination. I don't know whether they've done it aptly here, and then maybe they haven't, and it is very confusing. But it seemed to me that's what was going on here. The board was saying, yeah, whatever, you have that contract and you may have signed it, but that contract cannot allow you to impermissibly discriminate against a group that is otherwise protected by the successor rule.
I think the challenge, well, first is the board had no concern with the application to the vast majority of employees that work for Everport. But the challenge here is figuring out where it's kind of a shifting schedule or order. The contract binds Everport. Everport's required to comply with the contract. The parties to the contract agreed that the red circle no longer applied. Everport's required to comply with it for all sorts of workers.
When you say no longer applies with respect to what?
The red circle has expired.
No longer applies as a notion, or no longer applies in this situation?
In this situation, because Everport had taken over the terminal.
And that's where you have a direct collision with the successor rule. And that's where the board conceptually seems to be saying, you may be part of a contract, but you can't be part of a contract that discriminates against protected workers. That seems to be what's going on. We'll hear from the board. I mean, I'm trying to make some sense out of this. I understand you can't read a contract the way you and your Mr. Parrish are suggesting. Well, but there's a contract provision, and acknowledge that, and it's discriminatory. And it's therefore the board has bound itself. That's not the way it works. But I don't know whether the board has clearly said that. And I don't know whether it's justified. but I'm trying to understand what you all are saying. The red circle was part of that contract. And the only place the red circle notion has been eliminated is with respect to this unit that we're talking about that has always been represented by machinists, right?
I wouldn't say necessarily the only time, but at any time the employer that was employing the machinist ceases operations, the red circle.
That's the whole point. The question is, can a union and employer under a contract make that determination? The board says, no, we're making the determination. This is a successor employer. It's not an employer, as you claim in the contract, that has disappeared. That seems to be the fight that's going on here.
And to be clear, though, the board is not challenging the interpretation of the agreement that the red circle expired.
No, but they're saying it's discriminatory. They're saying, you're saying that the contract which expires it as to these people is discriminatory. You're agreeing with that. I don't know whether that analysis makes sense, but that seems to be what they're doing. They're saying, yeah, we understand what you're saying about the contract is exactly right. The problem is it's discriminatory.
And I think this leads to the dilemma that Everport is bound by the contract, bound to follow the contract, including the contract.
Well, see, that I don't know why that bothers the two of you. That's just not a troublesome notion. If a union or an employer claim to be protected by a contract that's prohibited by the National Labor Relations Act, that's no defense. You can't say, but I'm just following the contract. If the board legitimately says the contract, insofar as it does this, is unlawful. That's where I'm not following your two arguments at all. I am following your argument to the extent that you're saying we don't really know what the devil the board did here. We don't understand how they justified it. But I'm not following that argument. That is, but the contract says it's okay, and so we can discriminate and avoid the successor rule. I don't follow that one.
Yeah, well, I guess the first piece is it's not my position that there was discrimination. And the second piece is that the board has repeatedly upheld the application of these sections of the contract as being lawful.
Gotcha. Okay. I just want to make sure I'm understanding. We'll hear what the board has to say.
Thank you, Your Honor.
I'm not moving a tree. I was just thinking out loud.
Of course.
It's your job to tell us when we've done.
Noted. If my colleagues don't have additional questions for you, Ms. Malio, we will hear from the board now. Thank you, Ms. Malio. Mr. Sauter.
Good morning, Your Honors. May it please the court. Greg Sauter for the National Labor Relations Board. I'd like to pick up where all this argument is going and say, we basically have on one side Everport that's that starts with the Longshore contract and its provisions. And we, the board, obviously we start with the National Labor Relations Act. And the act says that employees have a right to decide who they want to select as their collective bargaining representative or nobody at all. Okay, so we have in this case a unit of machinists, of mechanics who have recognized the machinists as their collective bargaining representative. We now have a new employer, Everport, who steps in as a successor into the shoes of the predecessors. And because Section 7 and 9A protect the rights of employees to choose their own bargaining representative, Everport can't just walk in and say, because I'm a party to this other contract, I can completely ignore your choice of representative.
Mr. Sauter, though, that is to talk about this Longshore contract as if it's just some random private agreement that Everport entered into. But that's not what it is, right? I mean, the Longshore agreement is one that the board has ratified. It's been in existence for a long time. And I mean, it doesn't seem like the board disputes that for Everport to continue hiring longshoremen, they needed to join the PMA and they needed to have access to those workers. So it's not as though they're trying to hide behind, just a private contract that they came up with. It's a board sanctioned contract that they're operating under.
Well, all units that have been certified by the board are board sanctioned. But I would really push back against the notion that the the West Coast unit is somehow some kind of super unit that has prerogatives and privileges that other bargaining units or area-wide bargaining units don't have.
So let me ask you a question. So when Everport took over operation of the terminal, the longshoremen who worked there were members of the ILW. Is that right?
Yep.
So in order to retain those workers, wouldn't Everport have to join the PMA in order to have access to those workers?
Well, getting back to the question you've asked both Mr. Parrish and Ms. Maggio, the board does not dispute that in order to obtain stevedore labor on the West Coast, Everport has to join the PMA.
Okay, so that then is a law. I mean, and that's the only way they can continue to operate the terminal, presumably.
That's the only way they can continue to have stevedore labor at the terminal. Not maintenance and repair workers, but for stevedore labor, yes.
Right. So then what would you have had Everport do differently from what they did here? I mean, in practically speaking, in order to continue to run their business, what would be the action that they were supposed to take without running afoul of the board's various, either the successorship rule or the longshore agreement?
Right. Well, honestly, Your Honor, this comes down to, frankly, a business mistake by Everport. They initially thought that they could hire a contractor who would then be able to negotiate the issues between IM and ILWU. When that contractor flaked out on them towards September, they were their backs to the wall because they didn't have a backup plan. If Everport had hired an ILWU contractor to do the maintenance and repair work, we would not be where we are now. Everport could have terminated the previous contractors, said you guys are done, hired somebody new who would come in as a new employer, not a successor to the previous ones, a new employer who would come in with its own ILWU labor obtained from the ILWU Joint Hiring Hall. And voila, that's where we would be. But what they did is they put all their eggs in the basket of Joe Gregorio, who was already involved up to his neck in litigation, in this litigation between, other litigations, but related to the same issues between ILWU and IM. And after several months of hesitating, he decided he just couldn't take on another potential dispute that would bog him down in the courts. And he said, no.
Can I ask a question?
And at that point, I'm sorry.
Can I ask a question?
Yeah.
The alternative scenario that you've outlined, which is you replace the existing subcontractor, I guess, with a different subcontractor who's then associated with the ILWU rather than with the machinists.
Mm-hmm.
Then that doesn't implicate the successor rule because you still have machinists who have been there working and they would be replaced in that scenario.
The successor rule obtains, Your Honor, only if the new employer steps into the shoes of the prior employer. Mm-hmm. And that involves, substantial continuity of operations, continued appropriateness of bargaining unit, and majority of employees, mm-hmm. right? If you have a new contractor who's an ILWU contractor who gets their staff from the ILWU Joint Hiring Hall, he's not a successor employer. Now, if the ILWU Joint Hiring Hall can't give him quality mechanics to do his job, and he has to go back to the previous mechanics, the mechanics for the predecessors, and hire them, he can't discriminate against those mechanics and arbitrarily try to keep them under a minority so that he still has a majority ILWU bargaining unit. Do you understand what I'm saying?
I guess I don't understand why the subcontractor would not be a successor, but Everport is a successor. Right. If they're managing, maybe I'm not following.
Sure. Everport is a successor in this case because it started hiring from the predecessor's employers. Now, if it had not discriminated in hiring, right? at all. And it ended up with a majority of ILWU employees from the joint hiring hall and a minority of IM employees. Then it would not be a successor. Why? Because its employees are no longer of the majority of the previous
And
union.
how do you think they discriminated in hiring?
Oh, Your Honor, the record is full of evidence of that. They told Choi, who was running the system, actually told the employees that he was under orders to make sure that IM had only 49% of the resulting unit, and that ILWU would be 51%. They actually told. They actually contacted employees to schedule interviews and then rescinded those interviews, and in some cases rescinded job offers because those employees were represented by IM and not ILWU. It was.
You said if they had done it legitimately, in your view, whatever that means, and ended up with the same percentage, it would have been okay, and the longshoreman would have permissibly been the bargaining unit.
Yes.
Representative.
Yes. The problem is that they knew going into that it wouldn't happen because the ILWU knew that it couldn't give them the same kind of employees with the same kind of experience working on that very terminal, on those very machines. And they knew, therefore, that they had to figure out a system to make sure that ILWU would end up being the majority. I mean, Choi actually told his bosses, the power and crane mechanics that ILWU are sending me are not good enough. And then he went back, and even though there were crane mechanics from the predecessors who were qualified, there was no dispute about that. But instead of hiring from them, which would have put him over the 49% threshold, he went back, re-interviewed the poor quality ILWU mechanics and hired them. So yes, just to summarize the point, if Everport had run a completely impartial hiring process and ended up with a majority ILWU unit, it would not be a successor.
Can I ask this question? Because I'm getting, oh, go ahead, Judge.
I just want to follow up to make sure I'm understanding the argument and the facts. What do you agree? The analysis is so bizarre, the board's analysis, that the contractual provisions that they're following are not discriminatory? On longshoremen, is that contractual provision discriminatory or not?
I don't think it's discriminatory. I don't think the board held it was discriminatory.
Okay, wait. Okay, so you don't think it is, and the board didn't hold that it was discriminatory. The contractual provision says initially it was construed permissibly to red circle this area that we're talking about. Later, the interpretation, you're saying now conceding, permissibly said it's not a red circled area anymore. So under the contract that this employer was bound by, they're supposed to hire from the longshoreman. And you're saying that's not a discriminatory provision.
We're saying.
Then how is there a problem? Forget, wait a minute. Forget what they did when they came in and the nasty things that were said and all of that. Just take it at the contractual level. You're saying the contractual provision was not unlawful, and the contractual provision properly changed because the employer changed. The contractual. No. Wait a minute. I want you to understand what my premise is. The contractual provision, as the parties are construing it, changed so the red circle was gone, and they were obliged to hire from the longshoreman's hiring shop. Okay.
My turn?
Yeah.
Okay.
Your turn. So how do we have a problem?
So we are not disputing, the parties, the PMA and the ILWU, are free to interpret their contract as they see fit.
No, they're free within the bounds of the law. I'm getting you to confirm that the board is not saying that contractual provision is unlawful, right? The board has not premised its its decision on a finding that the contractual provision is unlawful, right?
No.
The
No.
contractual provision, as I'm understanding it, both from preparation and listening to all of you today, says for this unit, you have to hire from the longshoreman because the red circle's gone. You
Right.
have to hire from the longshoreman. That's what the contract says.
Right.
And you're saying that's not impermissible,
It's not impermissible for them to interpret their contract that way,
right?
but they cannot rely on their contract and use their contract as a basis to steamroll the Section 7 rights of employees.
No. You can't have it both. You can't have it both. I'll let my colleagues talk.
No, please. I think I'm following up on Judge Edwards in the following way. It seems to me it would be one thing if the employer said, what I want to do, I want to get the machinists out of there. I don't like the machinists. I want to get the longshoremen in. And the way I'm going to do that is I'm going to construe the contract so that it allows me to do that. So I'm biased against the machinists. I've got anti-union bias against that particular union. I want to make that work. I'm just going to come up with some argument under the contract. And then the board, I think, would be free to say, well, you can't act on bias against a union. That's an unfair labor practice. But it seems to me that your argument today sort of conflates two different things. One is I'm bound by a contract. I'm not acting on anti-union bias against one particular union. The contract just tells me what I need to do, and I'm just following the contract. That's one interpretation. And the second is a scenario along the ones that I outlined, which is that I have anti-union bias against the machinists, regardless of the contract. And I'm not understanding which one of those you're relying on. And because if you're relying on the second, then that's always a principle out there that an employer can't act on that basis as a means of evacuating one union and substituting a different one that's preferred, unless there's the requisite procedures to make sure that the employees, in fact, want that to happen. But it seems to me that you're equating acting under the contract and having bias against the machinists. And they seem to me to be two different things.
Well, your analysis omits one important player, and that's the ILWU.
Mm-hmm.
Everport here it's not Everport interpreting the contract. It's ILWU and PMA telling Everport what the contract says according to them.
So what?
But then it's either right or wrong. I mean,
So what? If they're telling them and it's not impermissible, if it was impermissible, this is what I'm trying to, and you no comment. The board is not finding that the contract provision is impermissible or unlawful. There's no such finding, right?
Right.
Okay. The contract provision properly construed, I don't care who's construing it or who's telling someone else to construe it that way. The contract properly construed got rid of the red circle, which means this group was no longer protected in the sense that machinists were there. This group was now subject to hiring from the longshoremen. That's the way the contract is interpreted, right?
Mm-hmm. Mm-hmm.
And that's the way the employer hired. I don't know if it's unlawful.
But that's where you hit up against
What?
the rights of the employees who are already there.
No.
You can't.
If a
It's
contract,
fine.
any
It's
contract
fine,
in-
Your Honor, if the employer hires from the ILWU hiring hall
right?
and doesn't intentionally screen out the others. That's where the discrimination
Anyone
happens.
who's on the other side of that process is going to say, I was screened out. And the employer's answer is, yeah, because I have to hire from the hiring hall. This is no longer a red circle under the contract that the board says is lawful. I have to go through the hiring hall. So yeah, you're asking me, am I intentionally going to the longshoreman's hiring hall? Yeah, I am. And then the employee or prospective employee says, well, that means they're preferred over me. Yeah. And so I'm not getting it. If the board has not, it seems to me the board cannot possibly reach this decision, which I guess is what Mr. Parrish was begging me to try and understand. If the board has not said that that contract, which the board endorses, is not impermissible, And then no one is disagreeing that the red circle is gone under the contract. And then all the employer did was to hire in a manner that's consistent with the contract. How can that be a ULP? In other words, what I'm suggesting to you is the reference to successor is bogus.
I strongly disagree, Your Honor.
Well, you can, but you got to explain how.
Right. Well, because the way the successorship analysis works is you step into the previous employer's shoes and you have to negotiate with the previous employer's employees. And if you have another contract telling you that you can't, well, that doesn't allow you to ignore what the National Labor Relations Act said.
The other contract that you're talking about is a contract that binds the employer, and the board doesn't doubt it. The board,
right.
But
it doesn't bind the employees who were there.
No, counsel. The successor, at least as you're now explaining, is a totally bogus analysis, because the board agrees that, yeah, they can step in here. This is the way it works. And part of what that contract that they are bound to follow, and we don't disagree with it, it's based on history, includes this red circling notion. And we agree that the red circle disappeared now because that's what their contract says. It disappeared. It wasn't intended to be discriminatory. It just disappeared. It's a new employer. And so under that contract, they have to go to the longshoreman shop. And that's what they did. You can't then somehow say the successor rule trumps if the board agrees that this contractual provision is of long standing and was in play and it's lawful.
Here's the difference, Your Honor. Between, I think what you're sort of alluding to is kind of the Kinder Morgan scenario here. In Kinder Morgan, you had an employer that had that contracted work to an employer that was connected to the electricians. The longshoreman came along and said, "This is our work. This is our turf. You can't give that work to the electricians." So what did the employer do? It got rid of the contractor. Well, we don't know what happened, but basically, based on the outcome of that ruling, what the employer would have had to do is get rid of that contractor and hire a new contractor with longshoremen. In that case, there is no disruption of the collective bargaining relationship that exists between the first contractors and the electricians, the first contractors' employees and the electricians. They are still represented by the electricians. Nobody has stepped on their Section 7 right to choose who they want to bargain for them. In this case, that's not what we have. We have a situation where Everport is acquiring the work, taking it in-house, becoming a successor employer, and then telling employees, you can't be with your prior union with IM. You have to join the longshoremen.
Could they lawfully sign the PMA contract?
I'm sorry?
Could that employer that you're talking about lawfully sign the PMA contract?
Which employer?
The one you're calling a successor. Was it permissible for them to sign the PMA contract?
Sure, there are.
Sure, okay.
There are employers who have multiple contracts with different unions for different units. That happens all the time. The problem here is
what you must be saying at the end of the day then is that it's okay for Everport to sign the PMA contract. It's okay for Everport to implement the consequences of that contract vis-a-vis the longshoremen, which means that they have to hire longshoremen as the stevedores. But it's not okay to follow the part of the contract that ended the red circle exemption with respect to the maintenance workers.
And that's not what the board said.
The board is not taking an opinion as to the interpretation of the red circle terminal. It's established that the parties to a contract can interpret their contract as they see fit. The board, so that's why we haven't said one way or another, and the board hasn't said one way or another whether that provision discriminates or not. But the end result here is absolutely discrimination.
Kinder Morgan was not a successorship case.
No,
Also, when the board fails to engage with that reasoning, though, it doesn't explain what the relationship is between this admittedly valid contract and the successorship analysis. I mean, isn't that ultimately the problem, is that the board nowhere engages with that,
well,
with that conflict?
well, I would submit, Your Honor, that what Everport's problem here is with the Burns analysis, which is turning 50 years next year.
But this is
the Burns analysis
and
doesn't.
this longshore contract is even older than that, right? You know,
Right,
the
but
longshore agreement. So
No,
The Burns analysis doesn't factor when you have an employer who is a successor employer or a putative successor who steps into a new situation and is already party to some other contract.
The problem is, counsel, under the Burns analysis, and you agree, the part of the test is the majority of the employees are coming from the predecessor. And that's easily avoided here permissibly because the longshoreman contract has been signed and the red circle is in play. So you can't meet the Burns test. They can easily avoid the 50% and permissibly avoid the 50% hiring. So you can't meet the third part of the Burns test.
It is, Your Honor, the fact that the contract allows them says that they have to pick ILW employees does not allow them to violate the law, which says that you can't discriminate against.
Which law? You're not talking about the successorship rule. You're talking about discrimination rule.
If they want to pick, like I said, if they had wanted to go at this above the board and just let the chips fall where they may, hire ILWU, interview ILWU, interview IM, and have the chips fall where they may, and they ended up with a majority ILWU unit, we would not have a problem here. They intentionally discriminated against the predecessor's employees, and they can't use the longshore contract as an excuse to do so.
Okay. We're going around, sir. Yeah, gotcha.
Okay, unless my colleagues have additional questions for you, Mr. Sauter, we'll hear from Mr. Rosenfeld now. Thank you.
Well, let me see if I can try to make some sense out of this, since I've been involved in virtually every one of these cases for the last 30 years. Judge Rao, the fact is that Everport could have hired stevedores, the people who load and unload the ships and operate the equipment off the street, and gone non-union. They didn't have to sign the PMA agreement. But I will concede as a practical matter that they had to sign the agreement and hire longshore employees, because otherwise there would have been massive pickets not more than 5 miles from my house.
Right.
And there are no other longshore, that is, workers who unload ships who have that training. So as a practical matter, as to the workers who load and unload the ships, they signed with the PMA and obligated themselves to hire longshore. But at that point, it was perfectly clear from the get-go that Everport, ETS, would be a perfectly clear successor, a successor to the former operator, STS, who had hired the same group of longshoremen. So Everport becomes what we call a perfectly clear successor, and that's all discussed in the judge's decision at length. She's got 30 pages, 25 pages of analysis of these issues, beginning roughly at page 371 or 2 of the joint appendix. That's also true of the watchmen. It's also true of the walking bosses, who are other units that the ILW represents. Perfectly clear, they're going to hire a majority of those people. They weren't going to go out and advertise for people off the street or look for other unions. But if they tried to operate non-union and hired enough longshoremen to load and unload the ships, the Teamsters could have come in and organized those workers and represented them. But that's just not practical. It's a different story as to the mechanics, because as Judge Edwards points out, if the ILW had enough mechanics who were available in the Port of Oakland to work at this facility, they could have simply said, ILW, send us all your mechanics, we'll hire them, no problem. And they would have been what we call a perfectly clear successor or successor. There would have been no discrimination because they were a successor and they hired people from the source, that source. The problem in this case was that as the Everport recognized this problem, and they thought the solution was to hire Joe Gregorio and his companies to do the maintenance work. Gregorio has a company that works up and down the coast, from Seattle to Los Angeles, has several hundred mechanics. That's his business. He could have supplied 25 mechanics easily to work in this facility, move them up from LA or from Seattle and move them here and work. And had he done that, there would have been no issue of successorship because he would have been a subcontractor. Gregorio talked to them and finally late in October said, I can't do this, I'm out of here. And SCS then didn't go look for another subcontractor who could perform the work. Simply said, okay, we'll take it in-house. And then when they began the hiring process, they then discriminated.
Jay, when you say the consequence of he would have been a subcontractor, the red circle rule would not have come into play. Is that what you're saying? The changed red circle rule. The red circle would have remained. Is that what you're suggesting? I'm trying to understand as a practical matter. In other words, if he was a sub, it's the same employer, but it's a sub. I'm not sure what you're saying. Because I'm not sure what you're doing with the control. Are you saying they couldn't sign the PMA if there was some problem there?
No, they could sign it.
Okay, so keep that in play, and I'm listening to you, but you can't take that out of play. They signed the PMA. The PMA says something about changed employer on whether the red circle is in play or not, and that affects where they have to look for employees, as I understand it.
Well, they thought that the red circle agreement was in play until the PMA, their association, told them, sorry, it doesn't look like it's in play. And so you're going to have to find another solution. And that created the problem here because they didn't learn this until September, but they were still relying on hiring the subcontractor.
Okay, I'm not being unsympathetic in not understanding the practical problems and trying to deal with this. Was that impermissible? That is, the PM's in play. Was that unlawful? Is that what the board said? They signed the PMA, and the PMA clearly gives preference to the longshoreman hiring off.
The signing of the agreement was not unlawful. It was the application of the agreement in this case because Everport never became a successor to the subcontractors who were IAM represented because they couldn't find enough longshore mechanics. Again, had the same situation existed for the group of
Everport never became a successor.
Never became a successor legitimately and with respect to the LW. They became a successor with respect to the IAM because the historic bargaining unit survived and they discriminated in hiring. In other words,
do you think that they were right or wrong to be persuaded the way you understand the facts, and I'm not disputing that at this point? They initially thought that the red circle exception, they being Everport, initially thought that the red circle exception would continue to apply. And the way you're describing it, they were then persuaded by others that it didn't apply anymore. Was that right or was that wrong?
Well, that's the right description of what happened. But as the judge points out, and the board adopted the findings at page 386 of the record, the red herring issue is really the red circle language is really a red herring. It's sort of irrelevant to this whole thing because what Everport did was, again, had they hired 27 mechanics from the LW, no question, there never would have been an issue because they would have been a perfectly clear successor, meaning from the get-go, meaning September or August of 2015, it was clear they were going to have a complete workforce or a majority workforce of LW members. The problem was they weren't what we call a perfectly clear successor. They couldn't make a decision which union would apply until they knew who the workforce was. If the workforce was all hired off the street, all non-union, they couldn't have applied the agreement until after those workers were hired.
If it doesn't matter to you if the red circle is a red herring, as you put it, or as it's been put, and it doesn't matter to you at all whether the red circle exception continued to apply, then that just means it doesn't matter to you at all what the contract requires.
Right.
Right.
No, that's right. In this case, it doesn't matter and can't be applied, although they could sign the agreement in the spring of 2015 and apply it to the longshore workers who load and unload the ships, because they always intended to, and everyone knew that they would hire from their predecessor, STS. They would hire all their employees. They didn't discriminate. They kept the same longshore workers coming in, and when the ship showed up, they'd unload the ships, they'd load them, they'd go away, they'd come back a few days later. It was the same group of longshore. Perfectly clear successor, no issue, no discrimination. But as to the mechanics, it was the reverse situation where they thought they had a plan, the plan fell apart, and then the only way that they could preserve their successorship with the LW was to discriminate against the IM mechanics because the LW didn't have enough.
Right. So, I mean, I understand the worldview that says that even if Everport thinks that the contract requires them to preference ILWU workers over machinists, it doesn't matter what the contract says. The law, meaning the NLRA, just doesn't allow that. You have to act as if the red circle exception just continues. The law just requires that. It's not that the contract, in fact, I understand that worldview as a conceptual matter. I guess it as the long argument this morning indicates, there's a lot of thought that goes into that and to understand how all these things interrelate. And I'm just not seeing that in the ALJ's opinion that was ratified by the board. The engagement at that level that leads me to understand why it doesn't matter what the contract says, and that the law, the way you're looking at it, which is that the NLRA just says, I don't care what the contract says, you still have to continue as if the red circle exception is in effect. That seems like a pretty significant conclusion as to which there's just an assumption that has to be right. And I
do not agree that they had to operate as if the red circle language was in effect. PMA said the red circle language didn't apply. From the machinist's point of view, we thought it did, but it made no difference because Everport had the right and the need to hire people directly. They couldn't subcontract it, which was their solution. I think Mr. Sauter is right that had they had PMMC, PCMC, Joe Gregorio taken the work, he would have had a total crew, would have been able to do the work. And there were other LW subcontractors who could have done the work. They just in November, that is Everport, didn't go out and try to find another subcontractor to do the work. They made the business decision to hire directly. They had already made the decision to hire directly the longshore workers, the loaders and unloaders. Now they made the decision to hire directly the mechanics. And they didn't in November know whether the crew that they hired, the 27, would be off the street, non-union. They didn't know whether they'd be ILWU. They didn't know whether they'd be machinists because they didn't know how the hiring would happen. So they hatched a plan in order to assure their right to continued representation of ILWU to discriminate against anybody who applied. They would hire 51% ILWU and 49% machinists. That was an unlawful scheme, and that's what the record is chock full of. That what they had to do at that point was say, we don't know. This is what a successor always does. They say, we don't know who we're going to hire. We're going to operate the same business. We're going to advertise for workers. We're going to interview the former workers. And if the former workers become a majority, we will recognize the union. That's what Byrne says. So they can hire from any source. It depends on whether they hire a majority. In this case, they didn't hire a majority of mechanics who were all qualified, all 27 of them, machinists, because they hired unqualified longshoremen and specifically said, we're going to discriminate and hire only 51%. And they lost the right under Love's barbecue to say, we are a legitimate successor. Love says you can't claim successorship status if the majority status depends upon discrimination. And normally the way it works is the successor employer says, okay, I'll hire, and only hires 40% of the union workers and then 60% non-union and says, hey, we're free, we're non-union, we didn't hire a majority. Here it's the reverse.
Okay.
They hired.
Are you saying, I'm not, one last question, I'm not following. Are you saying they were or were not a successor?
I'm saying they were a successor under Burns because for two reasons.
Wait, they were a successor what?
Right.
I'm having trouble hearing you.
I'm sorry, there are two tests of successorship under Burns. continuity of the work and of the organization.
Right?
There's no dispute of that. Number two, you have to hire a majority.
I understand. What's your conclusion? Were they a successor or not?
They are a successor as to the machinist. They are not a successor as to the LW, because they are not a successor because when the hiring was done, they discriminated against the machinist, and had they hired a majority of machinists, they would have clearly been the successor as to the machinist. And Love's Barbecue says, and successor cases cited by the board, that when you discriminate against the former employees and don't hire them because of their union status, then, or non-union status, you lose the right to simply say you're free of the former obligation.
What percentage, as best you know, in the pre-existing unit that was shut down and then reopened was longshoremen as opposed to machinists? What percentage were machinists? They weren't all machinists, right?
No, they were, okay. Let's go back. There are two different groups here.
In the very beginning, when this first started, this area, what percentage of the employees approximately were machinists handling the work that was there to be done as opposed to longshoremen?
I mean, at Ben Nutter Terminal or in Oakland?
The very beginning, when this all started.
But when this all started, up until December 5, all the workers performing the maintenance work were members of the machinists. On December 5, they were terminated.
Were there any longshoremen working in this area?
Yes, as there were some longshoremen working on December 5 and thereafter doing longshore work. And then when ships started coming in, stevedore work.
Not as maintenance workers, though. The maintenance workers were all machinists.
The maintenance workers were always machinists, right?
Always machinists until December 5, when they were all terminated. Then it changed because Everport began hiring to staff up a crew and they started hiring a few people here and there because they had to continue to do maintenance. And they hired people and then employed them through December. And then when ships started coming in, they of course hired much bigger crews of workers, the longshore workers, to load and unload the ships. And at that point, they hired up to 27 workers, it's all on the record, and they discriminated against the machinists and favored the LW, and they lost the right under laws to claim successorship as to the LW. They had the state obligation of successorship.
I think we have that aspect of your argument. I want to make sure there's not any other questions that we have for you at this time, Mr. Rosenfeld.
Now, let me just take off on one other point here, which is that
if you could do it efficiently, I would appreciate it.
Now, I think that the board's point here is that the successorship doctrine in this context trumps or supersedes the union's agreement. I agree that the LW agreement says we get to perform all the maintenance work. They don't in this facility. They don't in other facilities in Oakland. They don't in other facilities in Tacoma, in Seattle, because the machinists represent workers for other contractors and even for some other contractors who are parties to the same agreement.
Okay.
There's a history here, and that's the point.
Thank you. I appreciate that. Thank you, Mr. Rosenfeld. Mr. Parrish, we'll give you 3 minutes for rebuttal.
Yeah, thank you, Your Honors. So the entire case that has been framed, both by the relief that the board has ordered and in the charge that was filed, you can see this on JA 401, was that we engaged in discriminatory practices because we did not bargain with the machinists. That's the whole case. And so the discrimination flows from the fact that we are complying with the longshore contract. And I will just highlight what we've learned through this argument because it's clarified what I was trying to articulate, but I think your questions have pulled this out. Judge Edwards, as you heard, he is not saying at the board that the contract itself is discriminatory. In fact, we know that the board has consistently said the provisions are fine. We've also heard this morning that no one disputes that the red circle is gone because of the way that Everport relates to the existing machinists. We were told that. You heard the board's lawyer say we were told that. Everport was told that we must comply with that by both PMA and by the Longshoremen Union, and they are not disputing that interpretation of the contract. Judge Rao, you asked me earlier, and you've asked several times, did we have to join the PMA? The answer is yes. Then the next question is, was there anything unlawful about joining the PMA? The answer is no. Are the provisions fine? Yes. And the Ninth Circuit has held that the longshore contract specifically covers repair and maintenance work. All of that together means that this is not us engaging in a discriminatory practice. It's us complying with the system that has been set up by the board. Judge Srinivasan, you asked about the question of bias and you put your finger exactly on it. There is no bias here. There's allegation of bias. What there is an allegation of is an employer that is trying to do its best to comply with this Byzantine rules that the board has set up and now wants to change. But the rules are that as long as we are okay to join the PMA, as long as the longshore contract is controlling, then everything else flows from that. And this attempt to try to say there's additional discrimination doesn't work. In fact, if you take a look at the longshore amicus brief, if anything, the allegations work in their favor, not in favor of the machinists. So, Your Honor, I agree with, and I'll just finish here, Judge Srinivasan, you are correct that at a minimum, the court needs to send this back because no one can make head or tails of what the board has done. But Your Honor, if you listen to the concessions that have been made this morning and the concessions that have been made in the brief, there's only one result, which is that if they want to change the rules, they can do it prospectively. They can't do it retroactively on the idea that we've violated the law. Unless you have any questions, I want to thank the court for its time. We appreciate it.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
This honorable court is now adjourned until Thursday, November 18th at 9:30 a.m.